Hey guys, welcome back to the channel. Today we've got a wild one, an entitled Karen who insists on having a real attorney hold her hand while she plays lawyer and tries to represent herself in court. But before we dive in, a huge thank you to today's sponsor, Chapter. Did you know that most people on Medicare overpay hundreds, sometimes thousands, every year just because they chose the wrong plan? It's not really their fault. They're often misled by brokers chasing commissions instead of helping clients. That's why I've partnered with Chapter. They were founded by people whose own parents were taken advantage of, and they set out to fix the system. When you call Chapter, you'll talk to a real human who'll walk you through every available plan to find the one that actually fits your needs. The best part, the call is completely free. On average, seniors save over $1,000 a year, and with the holidays coming up, that's money back in your pocket where it belongs. So give them a call at the number on your screen, or check the link in the description to see if you're on the best plan, or if you could be saving more. Huge thanks again to Chapter for sponsoring this video. Now let's get started.
Ms. Benedetto, good afternoon. You can go ahead and come forward, please. And Ms. Benedetto, I'm going to go ahead and have you have a seat right there. Please make sure the microphone is in front of you and the green light should be on. That's really important so that we can make sure that everything that we are discussing here today gets picked up.
Can you hear me? Good.
Yep, I sure can. Okay, so we are before the court for a special set 2 o'clock calendar in City of Lakewood versus Gale and Benedetto. 2 different cases involving Ms. Benedetto, 25L000583 and 25L004426. Both matters are before the court today for pretrial conferences. By way of procedural history, Ms. Benedetto was last before the court. Let's see here, back on September 9th, 2025. At that point in time, Ms. Benedetto made a motion to the court to have her attorney of record from the Horwath law offices, and I believe, if I remember correctly, that was Ms. Arnold, although it was Ms. Capone that was present at that time with Ms. Benedetto. Ms. Benedetto made a motion to assert her constitutional right to represent herself and to proceed pro se. The court reviewed the waiver of attorney with Ms. Benedetto on the record, and the court was satisfied that Ms. Benedetto understood the potential risks that she was taking by exercising that right. Nevertheless, Ms. Benedetto maintained her request to proceed with representing herself, and the court granted her request to do so. Ms. Benedetto then, towards the end of the hearing, and that was on a regular pretrial conference calendar where a number of other matters were waiting, Ms. Benedetto made a further record that while she wanted to represent herself, she wanted to have standby counsel appointed to represent her. At that point in time, Ms. Capone, I don't know what her terminology was, but she essentially chose not to make a record, is my recollection. I could be wrong, but I believe that's accurate. Mr. Graham put the court on notice that the prosecution may very well object to, I believe, what he was concerned might constitute hybrid representation under Washington law. And Ms. Benedetto, we set the matter over to today so that I can ask Ms. Arnold and Ms. Capone's supervisor, Angela Horwath, who is the lead attorney at that firm, to be present because they were previously your attorney of record and would be the court's default choice for standby counsel if the court appoints standby counsel. And I also wanted to give Mr. Graham an opportunity to further elaborate on any concerns he had as the prosecutor. Again, the reason I didn't do that at the last hearing were time constraints. The issue that was scheduled to be addressed by the court today was a fairly limited one. I wanted to make sure that Ms. Benedetto, after having some time and opportunity to review the waiver of attorney, was still wanting to proceed pro se and represent herself, as she previously indicated. If the answer to that question is yes, then I wanted to next ask her whether or not she is continuing to request that standby counsel be appointed. And then at that point, if she is indicating that she is, I want to give Mr. Graham and Ms. Horwath an opportunity to weigh in as well. So first things first, Ms. Benedetto, good afternoon.
Good afternoon, Your Honor.
So Ms. Benedetto, at our last hearing, we started off kind of rocky, but by the end of the hearing, I think we were doing pretty well. I'm going to remind you that I'm going to do everything I can not to interrupt you, and I'm going to ask that you extend the same courtesy to the court as well as the attorneys, okay? I'm also going to remind you that everything is being recorded today, so this is all on the record, if you will. So, Ms. Benedetto, your true name is Gail Ann Benedetto, correct?
Yes.
Okay, and Ms. Benedetto, you had previously indicated to the court you wanted to represent yourself. Have you had any change of heart, or is that still how you would like to proceed?
All right, I paused to hear because this is the first time the judge directly asks her if she still wants to represent herself. Watch closely as she delivers a masterclass in dodging the question entirely.
I question how we can proceed because I just feel like I think the term is fatal defects in the process, such as the 48 hours to have the procedural due process, right? Which I was basically forced to push through. So I was denied the right to question the arresting officers as to their training or what exactly did Mr. Graham, under a penalty of perjury, say that he feels he has sufficient evidence beyond a reasonable doubt that I've done these things that I'm not guilty of, and in all actuality I was the actual victim on both of those occasions. And I would ask the court to investigate the address because I'm not the first one. I know of at least another woman before me. Her name was Stephanie. I don't remember her last name, but it's a pattern, and I don't know how deep it goes. But I just want to also put the court on notice that I've already been violated by my country to the betrayal of giving your citizens that you don't have any business arresting, putting them in a tribal jail that's 98% American is not tribal. It's money laundering or whatever you guys want to call it. It's fraud, and you just push everybody through. The fact that 2 different lawyers gave me the same script both times shows that that's your process and procedure, is to habitually and continuously deprive these people of their rights. And I meant for Nisqually to make me leave in 46 degrees raining weather on March 20th with no shoes, nothing but a small dress. I had no wallet, no phone, no nothing. I was passed out in my Jeep, completely unconscious when the police officers arrived. They didn't witness me doing anything malicious, and I did not do anything malicious. I had no malicious intent, and you will not be able to prove that beyond a reasonable doubt. So for him to lie and say that he has it, and for you to just continuously sign off. And also, I've discovered that a police officer, when he enters the charge with his badge number, automatically signs your auto signature to the warrant, so you don't have any knowledge of the warrant. That an officer is not a judge. Your whole thing is just, it's not going to hold up. And I would just move to a jury. I need my peers. I'm not going to accept fines. I'm not going to accept probation. There's no way we'll come to an agreement. I need my peers to say that you guys.
So, Ms. Benedetto,
and it's been over 90 days since the malicious intent. I didn't get my 48 hours. I had 2 public pretenders. So if you continue to work with them as your go-to, defenders, knowing that they're not defending, then it kind of lands on you at this point.
Not really. I mean, he wasn't the one charged, and he's not delusional enough to think his status places him above the law. But go ahead. Let's watch her continue expertly dodging the question.
So, Ms. Benedetto, the issues that I just heard you describing, what you raised is a number of issues that would be motions. Hold on. Motions to dismiss this case. Hold on. I let you finish. Now you let me finish, okay? I'm not contesting that. I think you do have the right to bring whatever motions that you think are appropriate if you believe your rights were violated. My question for you at this point is, people in criminal cases in this state, in this country, bring motions to dismiss every day. The question that I need you to answer for me is whether or not you want to be assisted by, for being represented by an attorney when you bring those motions or when you seek that relief, or is that something that you want to do representing yourself? Previously, last time we were here, you said, no, Judge, I want to represent myself. So is that still the case, or are you now thinking that you want to be represented by an attorney?
I mean, if you have a competent attorney who is going to do their job like they took an affirmation to do, not Horvath, or however you pronounce it, obviously her law firm has failed me twice, so I shouldn't be obligated, and I'm not obligated to accept any representation, especially from people that don't represent anybody but themselves.
So remember that, well, I shouldn't say remember. So under Washington law, if you qualify for representation at public expense, you don't get to choose your lawyer.
Right.
Now, I have appointed an attorney to represent you previously. You indicated that you did not care for that representation and that you wanted to represent yourself. The other option that you have is to hire your own attorney, and you do have a choice when you hire your own attorney who you hire to represent you, but you obviously have to have the means to hire an attorney. So I can give you time to try and hire an attorney if that's what you want to do, or you can proceed with representing yourself, or you can be represented by a court-appointed attorney, assuming you continue to qualify, but you don't get to pick that attorney, right? That attorney is picked by the court. So you may not like the choice, but that would be how that process would work. So knowing those three options, you can either hire an attorney, you can represent yourself, or you can take a lawyer that I appoint to represent you. Do you know how you want to go forward?
I have looked into different avenues, and nobody has so far wanted to, I guess, take on the case.
No way. You're seriously telling me that you went to two different attorneys and both of them independently came back with the exact same verdict, that you're completely out of your mind?
But also, I need at least 14 court days, I believe, per the rules to actually file the motions. So I wasn't even given enough time, which is why I brought them, because it said that if I didn't file it in the right amount of time, I could submit it for you to, I forget the word, but basically to go over review in court. But I probably don't have the whole thing exactly perfect, how it's supposed to be heading-wise and stuff like that. So I do need more time to prepare proper, I guess, notices or motions, although I don't feel comfortable moving anything, because I don't think that anything can move. I mean, like, literally have probably 10 or 20 violations that I can just name them, that you guys, your own rules that were not followed. So how can you, in your official capacity, knowing your oath and knowing the Constitution, right? How can you proceed just like what's Washington Constitution Section 1? What is that? Do you know that? Washington State Constitution Section 1? No.
So, Ms. Benedetto, I think I understand the point you're making. I mean, what you said is you don't believe that the rules have been complied with and that your rights have been violated. I understand that.
Well, not just my rights, but like
right. I get that.
RCW 1031-100, unlawful warrantless arrest. RCW 69.50.506, warrants required for drug cases. RCW 10.0.1115, accurate and correct. Oh yeah, I forgot about that. Your officers or somehow the court has misrepresented and fraudulently made up a Washington driver's license for me, which I don't have. And I beg you to show me my picture card, my paying for it, my signature for any kind of thing with the driver's license people. I don't have any contract. I'm not a commercial driver. I'm a Pennsylvania resident, as a matter of fact. I'm actually Pennsylvania Dutch.
Is Pennsylvania Dutch just a classy way of saying you've got an extra chromosome? Because I'm a Texan, and when I'm in Washington State, I still need a driver's license to get around. Same rules apply to you, Karen.
So I'm like, you gave a pilgrim to the Indians, like literally is what you did to me. Like, that is just, I mean, I just can't get over that. There's no way that that is okay.
So, Ms. Benedetto, you're wanting to
So they lied on police reports.
Hold on, don't interrupt. Please don't interrupt.
Sorry, I apologize.
So we're getting ahead of ourselves again. So you've identified a number of issues that you obviously feel very strongly about, and I respect that. The question that I need to figure out before we start dealing with those issues and dealing with those claims is whether or not you want to raise those issues and those arguments to the court by yourself, or you want to be represented by an attorney. So last time we were here, you said you wanted to do that yourself, but you were requesting standby counsel.
Is Ms. Horvath, is she willing to do it herself, to put herself behind the name of her company?
I have no idea. The first thing that I need to know is whether or not.
Because if she'll do it, I will give her a chance to redeem herself, and maybe I won't file bar complaints against those two attorneys of hers if she can actually do her job.
So, Ms. Benedetto, I will tell you.
Otherwise, they all go down.
I will tell you that threatening to file bar complaints against an attorney doesn't do any good. Your attorney is somebody who is going to assist you and represent you in a case, but threatening them with bar complaints typically is not a good way to develop
them in jail over the weekend. Like that person, oh yeah, they didn't want to go. I'm sure they refused to go talk to you today. You believe that?
So, Ms. Benedetto, what I think I hear you saying is that you are not wanting to change what you represented to the court previously.
I have to represent myself.
Okay, which is that you want to represent yourself. Now,
I don't want to.
That leads me to my next question, which is whether or not you are still requesting that an attorney be appointed to be your standby counsel.
I stated what I wanted.
I'm sorry?
I think I stated what I wanted.
I'm sorry, I couldn't hear you.
I would like Ms. Horvath herself to represent me.
Okay, well, now hold on, Ms. Horvath. You understand that a standby attorney...
Is she even an attorney?
Hold on. Please don't interrupt me. Remember that a standby counsel does not represent you, right? Because what a standby counsel does is tries to give you pointers or answer questions that you may have about legal procedure or rules of evidence, but they do not represent you because you have chosen to represent yourself. They're simply there to try to help you in certain limited ways, but they do not represent you because you're representing yourself. Mm-hmm. So my question to you is, are you still requesting that standby counsel be appointed in that very limited scope where they might be able to help you understand some of the evidence rules, they might be able to help you understand some of the courtroom procedure? Is that what you are requesting?
Yes.
So, it took her about 12 minutes just to admit that she actually wants standby counsel, but I'm not sure she even gets what that means. They're there only to help her understand court procedures. They won't touch developing or executing legal strategies, especially the kind of absurd ones that could put their own licenses in jeopardy.
Let me begin by hearing first from Mr. Graham. And so I'm going to give him, he's the prosecutor, I'm going to give him an opportunity to respond if there's anything he would like to put on the record regarding your request for standby counsel. I am then going to give Ms. Horvath an opportunity to weigh in as well. Mr. Graham?
Yes, Your Honor. Standby counsel is not a right. Ms. Benedetto can choose to hire standby counsel if she chooses to do so, but she does not have a right to have standby counsel at public expense, and so the city would object to appointment of standby counsel at public expense.
Thank you. Ms. Horvath, anything from you?
Sure. For the record, Angela Horwath. Your Honor, I would agree with Mr. Graham in that it is not a right. The question of finance is really not something that I'm going to address. In regards to whether I think it's appropriate, I've never been standby counsel or never been familiar with standby counsel at a pre-trial stage. I have myself represented in a standby capacity once a case proceeds to trial in a very limited, defined manner. And that can be appropriate in situations that can be helpful to the court and to the process. But I do not believe it is appropriate at a pretrial stage. If this gets set for trial, and that's something that Ms. Benedito decides to do, I think that this issue could be addressed. And if the court did appoint our office in a standby capacity, I would want very specific terms. The familiarity that I've had is that the contact is in court only, so there's not email communication, there's not phone communication. That would be reserved for an attorney-client privileged relationship. But rather, we'd be present at essential hearings such as motion hearings, readiness hearing, trial hearing. If Ms. Benedito had questions about the procedure or the court's ruling, or objections, rules of evidence, that's something that we could provide. It's more akin to like an encyclopedia rather than providing any insight or doing any negotiations, making any suggestions. So I just want to be very clear that that's the only capacity we would feel comfortable doing if the court decided to ultimately have us assist as standby. But again, I don't believe it's appropriate at a pretrial stage.
Thank you very much. So the court did have an opportunity to take a look at some fairly recent case law regarding Ms. Benedetto's motion for the court to appoint standby counsel, and the opinion that the court was looking at is a Court of Appeals opinion from 2024, State of Washington versus Bobby Darnell Gwynn. That's GWIN. The citation is 31 Washington App 2D295. And the Court of Appeals guidance on this particular kind of a request from a pro se defendant is that the trial court must exercise its discretion in determining whether or not the appointment of standby counsel is appropriate. Interestingly, the Court of Appeals has indicated that the request for standby counsel from a pro se defendant falls under Article 1, Section 22 of the Washington State Supreme Court, the Washington State Constitution, that provides that pro se defendants receive reasonable access to state-provided resources, which can include standby counsel in some circumstances. Some of the factors the Court of Appeals indicated that the court is to consider, which includes all of the circumstances surrounding the situation. It's not an exclusive list, is the nature of the charge. In Ms. Benedetto's two cases, there are two charges. Case number ending in 4426 is a charge of knowingly possessing a controlled substance, a gross misdemeanor, I believe.
Yeah. May I say that I do have a complete defense for that as well, because I was involuntarily drugged and kicked out, so I didn't knowingly possess anything. And if you're referring to THC, vape pens, that's...
Hold on, Ms. Benedetto. Try not to interrupt me, okay? The second charge is malicious mischief and third-degree domestic violence, which, in courts of limited jurisdiction, the domestic violence gross misdemeanors tend to be more towards the more serious end of the spectrum on charges before before courts of limited jurisdiction. So that's one of the factors the court is supposed to consider. The court is supposed to consider the complexity of the issues involved. Relatively speaking, I don't think the charges here or the elements of the charges are particularly complex. The orderly administration of justice, I am a little bit concerned about that. I think Ms. Benedetto obviously has some very strong feelings about this, and so I am a little bit concerned about her ability to represent herself and maintain order and decorum within the court. So that is a concern of the court. Fair allocation of judicial resources, that is something that does concern me, and I think weighs in favor of not appointing standby counsel, because frankly, the attorneys that represent clients at public expense in this court are already very busy. And so for me to appoint one of them to be standby counsel for a pro se defendant who's made a knowing and intelligent decision to proceed pro se, that is a little bit concerning to the court. And then finally, the Court of Appeals notes the court should consider legitimate safety and security concerns and conduct of the accused. There's nothing that I've seen from Ms. Benedetto that causes me to be concerned that she poses a risk to the safety of the court, the attorneys, or court staff. Ms. Benedetto, as I said, she has some pretty strong feeling that her rights have been violated in these cases, but at no point have I considered any of her statements or her behavior to be what the court would consider to be threatening in nature. So those are some of the factors that the court is supposed to consider in determining whether or not the appointment of standby counsel is appropriate. I'm also mindful of the argument that's been made by Ms. Horwath, which is standby counsel really is for the purposes of assisting with understanding procedure and rules of evidence and things like that, to assist a pro se defendant in a very limited capacity once it becomes clear the matter is proceeding to trial. And we're not there yet. So at this point, based on all of those factors, Ms. Benedetto, I am not going to appoint an attorney as standby counsel in this matter. These are both relatively minor criminal charges as criminal charges go. I think you do have the ability to articulate and make your own arguments as you have been doing. And if we get to a point where it appears that these matters have to be resolved by way of jury trial, then at that point in time, the court may very well reconsider the decision. But at this point, I don't, and I do agree with Mr. Graham, under Washington law, there is no constitutional right to standby counsel. I am going to decline to appoint standby counsel at this point. Now, Ms. Benedetto, what that means is we are now at the point where you are going to be representing yourself as you've requested, and that's a right that you've exercised. If at any point in time you change your mind and you decide you want to be represented by an attorney, please let me know, okay? The next step that we need to take in your case is what's known as a pretrial conference. Now that we've sorted out that you are going to be representing yourself. And hold on one second. And what I want to do is take care of a couple of housekeeping matters. First and foremost, have you received discovery in this case?
I have not.
You have not. Okay. Let me speak with Mr. Graham and see from his perspective what the prosecution's position is at this point on providing you with discovery now that you have elected to represent yourself. Mr. Graham?
Yes, Your Honor. This will probably be reminiscent of a statement that the city has made before to the court, but until the city receives a demand for discovery, the city does not release discovery. We have not received a demand for discovery from Ms. Benedetto yet in writing, and so once we have done so, then we would release it.
It looks like you'd better start studying law, and fast. The judge is allowing her appearance today to count as a formal request for discovery, but that's just one piece of the pre-trial and trial process, which has strict rules that both licensed attorneys and pro-SE litigants are required to follow.
Okay. So, in this particular case, Mr. Graham, I ordinarily, I think you're right on. I'm going to make an accommodation for Ms. Benedetto, and I'm going to not require you to file that demand for discovery. We will go ahead and allow this hearing to serve as notice to the city that Ms. Benedetto is requesting discovery. And so, Mr. Graham, I guess the next question for you, sir, is how does your office want to provide discovery? Does the city want to mail that out to Ms. Benedetto, or did the city want to prepare a discovery packet that she would be able to come by and pick up? How does the city want to handle the logistics of ensuring that discovery materials have been provided to her?
Yes, Your Honor. In this particular case, it's probably going to be simpler if the city were to mail Ms. Benedetto the discovery, just because then otherwise it requires coordination of letting Ms. Benedetto know it's available. I can't say that it's going to be done in the next day or two. I don't know. From my staff's perspective, how quickly they can get that matter done. Usually, I expected that it would be done probably by the end of the week. But I can't be 100% certain without digging through these cases to see if there are any videos that have to be then put onto various media and things like that. Sometimes that takes time. So I would say the city will be happy to mail that out to Ms. Benedetto.
This may be a silly question, but does the discovery, is that what's the bill of particulars? And does that include the audio recordings of me and the public defenders from Ms. Squally? Or how would I go about getting that for my evidence?
So the recordings that was on the record with you and your prior attorneys, you would be requesting audio files of court proceedings from the court counter. You would go out here and ask the court clerk. They would have to look up the dates and times, and then they could provide those recordings. Oh, it's available through the website apparently.
Really?
Yeah, I learned something new.
What website? Do I have to accept any terms like no, what do they call it? Like if you make an account, then you're giving us consent that you will have no expectation of privacy as far as in your phone,
No,
like in that privacy stuff.
no, I don't believe
Pennsylvania
that
has
is
stuff
the
like that.
case. It is simply you are requesting information, and that information is being provided.
You don't have to make an account in order to like.
I don't believe so. And if that turns out to be the case,
I've used it before, Your Honor. It's just clicking on the website. There is no account required.
thank you, Mr. Green. Okay, and so what we need to do at this point, because I am running out of time this afternoon, Ms. Benedetto, we have speedy trial in your case, and let me take a quick look to see when speedy trial runs.
I mean, it's already over for the first one.
No.
That was in March. How can you have a speedy trial when it was in March 19th?
So currently, speedy trial in your case, oh, that's the wrong case. Let me find that case now.
Your do I have permission to exit? Is there any
Yes,
other
Ms.
name?
Horwath, I apologize.
That's okay.
At this point in time, Ms. Benedetto's motion to proceed pro se has been granted. The court is not appointing standby counsel at this time, so your firm has withdrawn or I should say has been removed as the attorney of record. So yes, you are excused from future proceedings at this time.
Thank you. Have a good day.
Thank you. So let me pull that up very quickly because I did look at this in preparing for Ms. Benedetto's hearing today.
Your Honor, my calculation is that the Horwath Law offices were removed on September 9th to allow Ms. Benedetto to represent herself. And so 90 days from September 9th would be December 8th.
I think that's
There's
correct.
already way more than 90 days after March 19th.
So hold on one.
And I have a screenshot where it says those charges were cleared, and I paid the $200 for the window, and I didn't need a court to tell me to do that. I don't owe anybody anything.
Well, if the court rules that you owe the money, then you owe it, whether you like it or not.
So, Ms. Benedetto, what I'm looking at is just the most recent court order, which I believe contained a speedy trial waiver. Yeah, I did. And it set as a commencement date the date that Mr. Graham indicated, because that was the date that you elected to proceed pro se. And so, yeah, so speedy trial currently expires in your case on December 8th, 2025. Now, the reason I bring that up is because...
The day before court, it expired.
I'm sorry?
The day before court, it had expired?
No, the speedy trial expiration date is under the court rules. And so it's when you're out of custody, it's 90 days from a commencement date. And so the most recent commencement date is the last time you were in the court and you said, I want to remove my current attorneys and I want to represent myself. Under the court rule,
that date was already beyond the threshold, was it not?
Well, it was ongoing, but that action...
It wasn't not ongoing, it was cleared, from my understanding. I have
so,
screenshots, and I even have an email back to me from Pierce County saying that they didn't have anything, they didn't see anything.
So, Ms. Benedetto, I'm just letting you know what it looks like in the court file right now. If you want to challenge speedy trial at a later time, that is a motion that you can bring along with the other motions that you're indicating. Yeah, if you want to say, no, that is not my speedy trial time, it's been improperly calculated, you can do that at a later time as well. But what I want to do right now is make sure that as it currently exists, we are protecting your speedy trial rights. And so...
That have already been violated? You're protecting the violation of my rights?
Well...
And isn't it RCW 9A.48.090 and 9A.04.1110 defining the malice that the officer has to witness the action and be able to say independently that the intent of the malice was there? Your officer cannot do that.
So, Ms. Benedetto, we're not getting into the merits of that today. These are things that you're going to have...
He really needs to just dismiss the case. This is ridiculous. You're wasting everybody's time.
Your Honor, I've been very patient with Ms. Benedetto, and the reckless disregard for what the court is asking of her. But at this point, the city is objecting to the routes she seems to continue to go down.
And I note that objection. Ms. Benedetto, this is one of those where there is a procedure that has to be followed, that attorneys are held to that standard, and because you are a pro se defendant, you're held to that standard as well. So what we're going to do at this point in time is we're going to set a pretrial conference in your case, and at that next pretrial conference, Ms. Benedetto, please don't interrupt me, okay?
It's 48 hours if I'm detained. You had 48 hours.
Ms. Benedetto,
that's been gone.
I do not want you to interrupt me. At the next pretrial conference, which we are going to set, and we're going to set it here fairly quickly. Let's see, today is the 23rd of September. Oh no, I'm sorry, today is the 22nd of September. We're going to go ahead and set this for a pretrial conference on...
Can we go straight to the jury?
I've never seen a Karen try to fast-track her own downfall this aggressively. But no, there's a proper procedure that has to be followed. Even if she just wants to skip it and trample over her own rights, the court is obligated to protect those rights, which is why they're sticking to Washington's rules, not Karen's.
Well, we're gonna get there. We're gonna get there. We're gonna go ahead and set this for October 9th at Daryl, do we have available time on October 9th at 3 p.m.? Okay, let's go ahead and do October 9th at 3 p.m. And that will be the next pretrial conference. Now, Ms. Benedetto, let me tell you what I expect at that next pretrial conference, okay? By then, you should have received the discovery in the mail, okay? So you should have had an opportunity to review all of the evidence that the prosecution is relying upon in these two cases. Number two, between.
I object. That's not enough time for me to file anything. October 9th from today, that's not 14.
Well,
14.
that is, let's see, 8 days, so plus 9, that is 17 days from today.
Court days?
It doesn't have to be court days, I don't believe, but it's 17 days from today. And so what I would like to do at the
I
next
have
pretrial
4 days,
conference.
and I won't even have the discovery to
Hold on.
write and draft all of my.
Hold on one second. I want, at the next pretrial conference, I would like you to be able to confirm that you've received all the discovery and you've reviewed it. Okay, so you got it in the mail. And I want you, at that point in time, to be prepared to file motions for, on whatever grounds you believe that you're asking that this case be dismissed. You previously indicated a number of rights that you think have been violated. I want you to reduce that to writing so that the prosecution has an opportunity to respond and I have an opportunity to read whatever authority you would like the court to consider. And then at that time, we will discuss when or if we are setting this matter to hear those motions or setting it for trial, okay?
I have a supplemental affidavit questioning the legality and equal protection, and I have something else. I don't know what they're.
Yeah, and those are all things. Those are all things that you're going to be able to file at the next pretrial conference.
Can I file them today?
I would like you to have the discovery before you file motions because I'd like you to know what the evidence is against you.
There's not really much more to the affidavit. Omnibus, I guess. To be.
Yeah, so we don't do omnibus hearings. We do what's called pretrial conferences, and they're very similar. But that's going to be the next hearing.
Join all unlawful and illegal proceedings, including requests for sanctions, redress, and formal objections to procedural substantive violations, breach of official misconduct, which is felonious.
Yep, and you will have the option of filing and raising whatever motion that you think is appropriate.
No, because you guys don't follow your own rules. I can name 20 of them.
I'd bet you couldn't count to 20, let alone spell it, without an edible crayon to guide you. And trust me, you're going to want to bring the whole family-sized Crayola box and maybe a little computer duster to court because you're going to need every bit of help you can get trying to represent yourself with a room temperature IQ. That's it for this video. They've scheduled her next appearance for next month, so it looks like we'll be seeing her again sooner rather than later. If you enjoyed the video, hit that like button. If not, hit dislike. Don't forget to leave a comment below and subscribe with notifications on so you never miss any of my content.